to be among young people and talk about an issue uh, which is very important for the country, for our democracy, for society in general. So, if you look at the Constitution of India, you find that the judiciary, especially the Supreme Court, the higher judiciary, Supreme Court and the High Court, have been assigned a very important responsibility, and that is to protect the Constitution, to protect the fundamental rights of citizens, and to ensure the rule of law. Of course, an important role of the judiciary is to decide disputes between citizens and the state. But an equally important role of the judiciary is also to protect fundamental rights of citizens against intrusion or violation by the state primarily, and also to ensure that the legislature and the executive function within the bounds of the Constitution, within the bounds of their powers assigned by the Constitution, and that the executive does its duty, because every power that is given to the executive is coupled with a duty to exercise that power whenever there is a need to exercise that power. So wherever the judiciary or wherever the executive does not exercise the functions which have been entrusted to it by the Constitution, it is the role of the judiciary and the job of the judiciary to issue a mandamus, which is a command to the executive to perform their duty and ensure that there is rule of law in accordance with the Constitution, that is, without violating any rights or any fundamental rights of any citizen. So it was to fulfill this role, that is to enforce fundamental rights, to ensure the rule of law in accordance with the Constitution, to ensure that the executive function within the bounds of their powers and perform their duties, that the Supreme Court initiated public interest litigation. Now, the whole concept of public interest litigation was that a citizen, any citizen, pro bono, meaning ki in bona fide and in public interest, could move the High Courts or the Supreme Court for redressal of a grievance which was common to a large body of citizens. It could be a group of poor citizens who could not approach the court themselves, or it could be citizens in general. So you could raise an issue of the larger issue of environment, which would affect citizens in general. You could raise the issue of the civil liberties or the socio-economic rights, like the rights of rickshaw pullers, the rights of street vendors, the rights of jhuggi dwellers, who are too poor to move the courts themselves. And for this purpose, the Supreme Court expanded the meaning and the interpretation of Article 21. And they said, and they held, that the right to life guaranteed by Article 21 of the Constitution does not mean the right to live an animal existence or just to exist. It means the right to live with dignity. And for that, whatever is required to live with dignity should be guaranteed by the state to every citizen. So basic shelter, food, basic sanitation, basic education, basic health care, as well as a proper and healthy environment, and to some to the extent that is possible, a corruption-free society. Those were all included in the expanded meaning of Article 21 rights. So the Supreme Court started saying that we will not merely enforce absolutely legally guaranteed rights which have been guaranteed by any particular law, but we will also ensure that is that the environment is protected, which is a general requirement of every citizen in the country, that to have a reasonably clean, pollution-free, sustainable environment. So to that extent, they started issuing writs of mandamus to the government to do this or that, or not to do this or that, regarding deforestation, regarding air pollution, regarding water pollution, etc. Similarly, issues of civil liberties, basic civic rights, that is, rights of under trial prisoners, rights of people living in asylums, rights of bonded labor, etc. These were all civic rights, and the court started issuing directions even on those issues, or on many of those issues, on behalf of citizens in general. Then there are social justice issues. So the rights of poor people, for example, the rights of rickshaw pullers to be able to ply the rickshaws in a reasonable, fair manner for earning a living within the limitations of whatever the traffic regulations may be, etc. That is, the right of rickshaw pullers not to be unduly harassed by the authorities, or not to be unduly restricted by the authorities. Similarly, the rights of street vendors, that street vendors have a right to earn a living, and they have a right to vend on pavements on the streets without, of course, causing any serious obstruction for pedestrians, for traffic, etc. Therefore, there cannot be undue restrictions on the rights of street vendors to vend. Similarly, then they finally they came to the issue of corruption, because the court also said that living in a corruption-free society is also a right under Article 21. And therefore, they started issuing various directions, whether it was, say, let's say in the 2G case, that if corruption has happened in the grant of licenses for 2G mobile telephony, they started a court-monitored investigation to ensure that those who had indulged in corruption were brought to book. They also said cancelled the licenses which were given in this corrupt and illegal manner, and they said that licenses will have to be auctioned after that. That whole business of first come, first served, they held, was totally illegal in a matter like telephony, which was a very, very valuable, in the grant of spectrum, etc. Same thing in the coal mining leases. And then they came to the issue. So there are specific, many specific issues of corruption, whether it was in the grant of coal mining leases, or whether it was in the grant of 2G licenses, etc., where the court said, or in the Hawala case, the court said that we'll monitor the investigation. We will ensure that the investigating agency, that is the CBI, does its job that is entrusted to it by the law, that is to investigate it without fear or favor, without being deterred by the fact that the investigation may be against people who are in power currently, who are holding the posts of ministers, etc. So this court monitored investigation was another tool fashioned or continuing mandamus, which means that we will keep the case pending and we will continue to monitor the investigation until we are certain that the investigation has been completed or that it is on the right track and it is not likely to be derailed by those who are in power. And then finally, the court also started entertaining PILs. Of course, there were PILs to challenge appointments to various public and constitutional posts, like the Supreme Court struck down the appointment of the Central Vigilance Commissioner on the ground that he was himself being investigated for corruption or should have been investigated for corruption, and therefore he was not qualified or unfit to hold the post, or that this aspect of his CV was not looked at by the appointing authorities. Then there were other issues of institutional reforms, which the Supreme Court started taking up under public interest litigation. So one of the first cases of institutional reforms was the case involving the CBI, where the court said, it was in that Hawala case itself, the court said that, see, we cannot, they found that the CBI, being directly controlled by the government and having to often investigate cases of corruption against government officials, find itself hampered. And therefore they said that in order for the CBI to function independently and to do its investigation impartially without fear, they need to be made independent of the government to some extent. And therefore they said that, all right, the CBI director will not be chosen by the government alone. He will be chosen by a committee of the Prime Minister, the Leader of Opposition, and the Chief Justice of India. And he will enjoy a tenure of at least 2 years, during which time he cannot be removed except by taking the concurrence of the appointing committee. But that was an important step towards making the CBI a little more independent of the government. Then they also said that the CBI will function under the supervision of the Central Vigilance Commission. And the Central Vigilance Commission will be made into a statutory authority where vigilance commissioners would also have to be appointed by a sort of larger committee, not just by the government, etc. So that was a case where the Supreme Court used the tool of public interest litigation to force institutional reforms. And in that they said that these directions will hold good till such time that the government brings in legislation by amending the CBI Act and amending the CBC Act in order to bring those acts in line with our directions. And therefore, they virtually, I mean, the Supreme Court has held that the court cannot issue a direction to the legislature to bring about a law. But to get around this problem, they have said that though we cannot issue a direction to bring about a law, we can issue a mandamus to the government to put in place systems by which this kind of system will function, where the CBI chief will be appointed by this collegium, where those directions will have the force of law till such time that the law is amended to bring it in line with these directions. Same thing they did with the whistleblower on the law of whistleblower protection. They said that we want or we direct that the Central Vigilance Commission shall function as the nodal body where whistleblowers within the government who have some information about some wrongdoing, some corruption within the government, they can blow the whistle and make a complaint to the Central Vigilance Commission. And the Central Vigilance Commission would thereafter investigate that or get it investigated by any investigative agency, etc., and thereafter take proper action, and that the identity of the whistleblower should be concealed. The fact that this has not done much good is a matter of a different longish talk about why, despite these directions, the whole whistleblower system has not functioned very well. That's because the CVC has not really done its job in the manner in which it was supposed to have done. So despite the ordering of some of these reforms by the Supreme Court, some of these reforms did not become very effective. That's a different issue, which we can discuss as to why the directions regarding CBI didn't become very effective, or why the directions regarding CVC and whistleblower protection did not become very effective. But the fact is that the Supreme Court held that where they find that there is an institutional weakness in a system which is resulting in some authorities not being able to do what they are supposed to do, that is, not being able to investigate corruption properly, there they can issue a direction for bringing about those institutional reforms, and the directions of the Supreme Court will hold good till such time that the law is amended to bring it in line. Same thing they did about police reforms. They issued various directions, 6 directions about how the police needs to be reformed in order to make the police a little more independent of the government. So they said that the police chief should also be selected in this manner. He should have a fixed tenure of at least 2 years, that the mid-level, field level officers should also have a fixed tenure, that is the SHO, etc. That at least a minimum fixed tenure, you can't subject them to frequent transfers. Then they said that there needs to be a state security commission to keep an overall view of how the police is functioning, etc. So there were various directions given. Now, unfortunately, 15 years have elapsed since these directions were given by the Supreme Court. But in these 15 years, unfortunately, those directions have not been implemented by most state governments, and certainly not by the central government. As a result of which, the police still continues to function under either the central government in Delhi or under various state governments. So the police reforms which were directed have not been done, and unfortunately several of our contempt petitions are pending in the Supreme Court, but they have just remained pending. There are petitions which are pending in the Supreme Court regarding some reforms of the CAG and the Election Commission, especially regarding appointments of the election commissioners and the CAG, because today the government alone controls their appointment, and we have gone to court saying that these should also be done by a collegium of a similar kind of collegium which has been instituted for the appointment of the CBI chief. So these are various institutional reforms. Now, many important issues arose in the course of handling of PILs. I'll mention some of them. One of them was some courts started taking a view, wrongly in my opinion, that if you are an interested party yourself, you can't move a PIL. So, for example, if an issue of corruption has been raised against the government, then such a PIL cannot be filed by an opposition political party or somebody connected with the opposition political party. Now that to my mind is a totally wrong view, because in a PIL you have to see whether the cause that has been brought before the court is a cause in public interest or not. Even if the petitioner has some interest in the matter, that is, they want to show the government in a very poor light, they want to expose the government, that does not mean that that cause, if it is a justified cause, should be thrown out. If you feel that the petitioner in this case may not pursue the petition bona fide and may use it as an instrument of blackmail, etc., then if you still feel that the cause is just, the cause is justified, but that the petitioner is a shady person who cannot be trusted, then the way for the court is to remove the petitioner and to appoint an amicus curiae for taking ahead the carriage of proceedings. That is, remove the petitioner as the dominus litis, so to say, and hand that over to an amicus appointed by the court. But unfortunately, some courts have taken the view, though that's a wrong view, that if the petitioner has some interest in the matter, then they will not entertain a PIL at the behest of such a petitioner. Then there is another issue of frivolous PILs. See, there is this general view that has kind of taken hold, that a very large number, or perhaps the majority of PILs which are filed are mala fide or frivolous PILs. Now, it is true that lately, in the recent years, there have been a spate of what I consider to be half-baked PILs or PILs filed without doing adequate due diligence and research, and being filed in order to get some cheap publicity. There are also PILs which are being filed today which are for getting a matter dismissed, so that it kind of bars a genuine PIL on that issue in the future. Because then the government goes and says, look, such a PIL was filed earlier and it was dismissed. And sometimes the court dismisses the subsequent PIL also, even though that might be much better, that might be properly researched, that might have been filed after due diligence, and the cause may be very important. Yet because the earlier PIL was filed without due diligence and filed in a very casual manner, without putting across the proper evidence or putting across the issue in the proper perspective, and therefore it was dismissed, that should not mean that the subsequent PIL, which is properly filed, properly researched, should be dismissed. This brings me to a very important issue. See, the principle of res judicata should not normally be applied to PILs. It can be applied, and it is applied when there is an individual petitioner who has agitated a cause, he has lost it, he can't re-agitate the same cause again. But here, when there is an issue of PIL, the court has to examine whether the issues raised in this PIL have been properly considered and decided in the earlier matter or not. If a PIL is filed for the same relief, but certain issues and certain grounds were not agitated in the first PIL, which was dismissed, and they are being agitated in a fresh PIL, which is being considered, then res judicata should not be the ground for dismissing this PIL. And that is why I have always maintained, and I have always tried to practice this policy, that before filing a PIL, one has to be certain that you have got the best available or the best possible research on this subject. You must consult the best possible experts that you can find on that subject, even if that process takes time. Understand that issue properly, and thereafter only approach the court. So one important thing is that you must do your homework properly, very diligently, find the best experts, get the best understanding on that subject, and then only go to court with the PIL. The second thing is that when you go to court, you must be clear about what is the prayer that you are seeking. Because very often people go to court with a PIL saying that there is a lot of corruption happening and please pass orders to remove this corruption. Now the court will say, look, what kind of orders should we pass? How can we remove this corruption? Suppose you go to court saying that there is a lot of poverty in this country, issue orders to remove poverty. The court will say, look, we know that there is a lot of poverty, but how can we order that poverty should be removed? You give us some action plan. You give us some actionable order that we can pass, which is capable of being implemented by the government, on the basis of which we can say, well, if this is done, then poverty will be substantially reduced, or that if this is done, then corruption will be substantially reduced. If this is done, then environment will be substantially improved. So you have to go to court always, whenever you file a PIL, you must always think of the prayers that you want to make. And those prayers must be such that they are capable of, they are actionable. That means they are capable of being implemented, even if such a direction is issued, they are capable of being implemented by the government. This is a very, very important practice in PILs. Then there is this issue of delay and laches. Sometimes PILs are dismissed on the ground that, look, this is very delayed. For example, you may challenge the privatization of some PSU on the ground that it violates the law. That the law says that this kind of PSU or this bank has to be in the public sector, has to be held by the government. And yet the government has privatized it. Now you may bring it up. It's possible that nobody brought it up earlier. Now you came across it. You came to know that this has happened totally illegally. And you bring it to the notice of the court and you file a PIL saying that this privatization is totally illegal. Now, the fact that you have come after several years of the privatization having happened should not necessarily mean that your PIL must be dismissed on the ground that this is delayed or you should have come earlier. Because this is a matter of public interest. Even if it is delayed, the court can certainly adjust equities. If some other private party interests have come in and those interests have to be taken into consideration, the court can consider that. But not dismiss it outright on this ground alone. So this is, these are just a few thoughts that I had on the role of the judiciary and PILs, etc. I'll just very briefly mention that, of course, there are serious problems in the way that the judiciary has been functioning lately. One problem, of course, is that there are too many cases which are pending. Cases don't get decided within a reasonable time, and now with lockdowns and only electronic functioning of the courts, even fewer cases are being heard and decided. So the pendency is rapidly increasing and cases are taking even longer to get decided. This is one problem. Another problem is that so far as poor people are concerned, they don't have money to afford lawyers. Therefore, they cannot approach the courts realistically. The third problem is that even when cases come to be decided, let's assume that they come to be decided in a reasonable time. Even so, very often the case is wrongly decided because either the judge is incompetent or the judge is corrupt. Corruption is a major problem. And competence of judges is also a major problem. So there is both a problem of incompetence and a problem of corruption. That is, there is a problem with the manner of appointment of judges and the manner in which judges are selected. And there is a problem with the accountability of judges also. So we need reforms on all these things. We need, there is this Gram Nyayalaya Act, which is supposed to set up courts at the tehsil level. Now, unfortunately, just one second. You help your mother with this, with whatever. Sorry. So, we need all kinds of reforms. We need to set up these Gram Nyayalayas. We need to have more judges. We need to improve the method of selecting judges. We need to have a credible body for entertaining complaints against judges and holding them accountable, etc. All kinds of reforms are required in the judiciary. We need to do away with this whole system of the Chief Justice being the master of roster in order to improve the independence of the judiciary, because Chief Justice alone controlling the whole Supreme Court is not a very good idea at all. There should be at least a collegium of 5 senior judges who should decide the roster and which cases will be heard by which benches, etc. So just these are a few ideas about judicial reforms. I don't have the time to get into it in detail. I'll stop here and we can take a few questions for about 15 minutes and then I'll have to go. Thank you.
Thank you so much, sir. Thank you so much. So I would like to request the participants to ask your questions by unmuting your video and audio. Directly, you can ask your questions to sir. Participants, I request Anandraj sir to ask his questions. Sir, you can unmute your video and audio and you can ask your questions. Sir, are you there? Mr. Anandraj sir?
Yes, I'm here. I'm here.
Yes.
Sir, good evening, sir. I'm happy. I don't know where to the audio, video. I don't know where.
Okay, sir. Okay, you can ask your question, please. Sir, you muted your audio. Please unmute your audio and ask your question. Sir, can you hear me? You muted your audio. Mr. Anandraj, sir?
Yes, now is it audible?
Yes, sir, it's audible, yes.
Okay, sir. So good evening once again. Very happy to talk to you, such a person like you. So in a judicial term, I do not know anything about it, but in the common aspect, may I ask one question, sir? The most of the people, especially the affected people, they won't approach the court for 2 reasons. As a general reason, maybe the timing and cost, but generally they do not have any idea about the constitution and what are the privileges to the common idea. And even one of the related members are missing means they are not able to approach under the habeas corpus. In such a situation, what kind of reforms can be done to the common people, and we can create the awareness through the various education system If can't we give the kind of awareness program like that, sir?
Yeah, so there should be general education about broad principles of the Constitution, fundamental rights, etc. That should happen in the school itself, in the schools themselves. And otherwise also, I mean, lawyers can always undertake, and now with online classes, they can always undertake, some public spirited lawyers can undertake sort of basic short courses or programs to educate people about rights in general, or to educate different categories of people. Street vendors can be educated about their rights in accordance with the Street Vendors Act or the Supreme Court's judgments, etc. Similarly, Jhuggi dwellers can be educated about their rights, and so on. This is the role of public spirited lawyers, or kind of legal NGOs, which should prepare small pamphlets and distribute them, leaflets, pamphlets, distribute them to affected sections of society so that they are made of in a language which those people can understand. That would certainly be helpful.
Thank you, sir. Thank you, Anandrath, sir,
Thank
for
you,
your
sir.
question.
Thank you, sir.
Sir, as an organizer and as a host, I have a small question to you. This is the question many are expecting to ask to you, and I am bold enough to ask that question. And what is your views on independence of judiciary in India? Why I need a small answer, not a big answer.
The judiciary needs to be independent. Unfortunately, we have been seeing for some time that it had ceased to be independent. And in every important case, the Supreme Court was deciding in favor of the government, however bad the government's case may have been. We were seeing that for the last 4-5 years. But it appears that things are becoming better. They are changing for the better, at least in the last couple of months. And let's hope that they will continue to improve.
Thank you, sir. Thank you. Next, I would like to request Kripa to ask your questions. Yes, Kripa, you can ask your questions. We'll be winding up by 5:55. We have 8 minutes. Yes, Kripa, carry on.
Very good evening to you, sir, and the organizers. I'm a second-year law student, and it's a big opportunity to me to hear from such an eminent lawyer of the country. Sir, what bothers me is the delay that we face while giving someone, or by the system of justice in India is actually being very delayed. So, what can be done to at least not speed up, I would say, to decrease the time that takes in the entire procedure? Because there are certain cases like the famous one, the Nirbhaya case. She died, and her mother kept fighting for the justice. So, sir, what is the solution for this, sir?
Solution is to have more judges and better judges, better quality judges, and more judges. So we need to improve the system for selecting judges, and we need to set up more courts.
Thank you, sir, for your answer. Sir, is the current way of selecting judges is not sufficient, or does it have any loophole?
Yeah, there are many problems with the selection of judges. See, judges of the lower courts are selected usually by some exam, etc., which is conducted by either by the high courts under the supervision of the high court, or under the State Public Service Commission. And there are all kinds of problems with these exams. And one particular problem is the system of interviews, which is totally arbitrary. The other High Court and Supreme Court judges are selected by a collegium of senior judges of the Supreme Court. But there is no transparency, there is no system. It's also very arbitrary, nepotistic system. So we need to have a permanent body called the Judicial Appointments Commission, which should be a full-time body, not an ex officio body, but which should be independent of the government, totally independent of the government. And they should select the judges in a transparent manner. That's what needs to happen.
Thank you so much.
Kripa. Thank you so much, Kripa. So next, Harshit Chaudhary, if you want to ask your questions, you can ask. You can unmute your video and audio and you can ask it.
Thank you so much, sir, for this insightful session. First of all, it was a pleasure to hear from you. Sir, as far as I know, PIL was introduced to promulgate social justice. So, can I issue in interest of a certain section of a society, but not in the interest of some other section, be a subject matter of an PIL?
No, you can have a PIL for people in general. So it need not be for any poor section, etc. So corruption PILs are for people in general. Or environmental PILs can also be for people in general. But yes, certain PILs, for example, for rickshaw pullers or for street vendors or for chuggi dwellers, those are for certain sections of society which are poor.
So, my question was more pertinent to the stray animals. Like, can a person file a PIL for those animals because they cannot even speak for themselves?
Yes, yes, there have been PILs for animals also.
Thank you, sir.
Thank you, Harshit Chaudhary. Next, Shankar Ganesh, you can ask your questions. You can unmute your video and audio and you can ask your question.
Sir, good evening,
Yes.
sir. I'm a student of law. I'm doing final year at School of Excellence in Law. My question is, is courts or overrestricting, especially with respect to fundamental rights enshrined in Article 21 of the Constitution? Recently, Honorable Meghalaya High Court said that compulsory vaccination is infringement of fundamental rights. If right to health is fundamental right, does it not include good health free from diseases?
Yes, right to health means good health free from diseases, but see, every citizen has a right to choose, that there is a right to informed choice about what kind of treatment you will receive or what you will not receive. That includes vaccines also. So nobody can be forced to take a particular medicine or a particular vaccine against his wishes. And he needs to be given proper information about what that drug or what that vaccine entails. What are the pros and cons of that? And then that person is free to make an informed choice.
Thank you, Mr. Shankar Ganesh. Next, I would like to request Shirsha Chaudhary to ask her question.
Hello, sir. It's an honor to ask you a question. I'm a fourth year student of Judicial Chaudhary Law College, and I have a very naive question. That is, as you said that from socio-economic backgrounds, many people cannot afford an access to sought legal help or judicial help. So just from schooling or awareness in schooling and free programs, are they enough for helping them in any way? Because there are a large sector that do face issues but are not able to sort for judicial help. So what your
Yeah,
say in it?
that is
How
not
can we
enough.
reach a larger sector?
Yeah. So awareness by itself is not enough, because you need to ultimately be able to go to court to agitate those rights, etc. And normally in the present system, because the procedural laws are so complex, you can't do it without the help of a lawyer. So we need courts which are informal for at least normal disputes. For ordinary matters, you need to have courts which do not require a lawyer, where you can go and just say what your problem is, and some paralegal help can be made available to you so that you can explain what your problem is to the judge, and thereafter the judge should be able to deal with it. It should not require all this civil procedure code or criminal procedure code, etc. Go through to negotiate that. So that is what ordinary people cannot do, because for that they need lawyers. So the normal system of normal courts in normal cases should be very informal, where you don't need lawyers. And the whole concept of Gram Nyayalaya was exactly that Gram Nyayalayas would be informal courts at the tehsil level, should not require the use of lawyers.
Thank you
Thank
so
you,
much. sir.
Sricha Chaudhary. Last question. Mr. Uma Mageshwaran, you can ask your last question.
Am I audible, Pastor?
Yes, you're audible. Yes, yes, yes.
Yes, sir. Good evening, sir. Good evening. It's a pleasure to ask a question to you. You had the talk of the month in the last year where you tweeted about the Chief Justice of India. Then, as a famous, one of the topmost lawyers in India, from where did you get the guts to question the Chief Justice of India? And have you paid your contempt penalty of ₹1? That's my
Yeah,
question.
that ₹1 I had paid long ago at that time itself. So guts is a matter of, you see, the way that I look at things, I feel that since I am somebody whose voice is heard, it's important for me to say what I believe to be right and what I believe needs to be said. And sometimes saying that may have unpleasant consequences, but one has to be prepared for that because that's your public duty and public responsibility, especially if you have been given some power over some influence over society, like I have been fortunate enough to have. So then one does what is needed.